Well, as I've mentioned, the application for State Prosecutor Advocate Billy Downer to recuse himself from the Jacob Zuma corruption case will continue in the High Court in Pietermaritzburg today. Our reporter Ayanda Mhlongo is standing by to give us those details. Ayanda, a very good morning to you. Thank you so much for joining us. What do you have for us this hour?
Good morning to you, Simpur, and good morning to our viewers once again. Well, the application by former President Jacob Zuma, as you said, to seek the recusal of the State Prosecutor Advocate Billy Downer continues this morning. What we expect this morning is the State, who yesterday made their submissions, they're going to be concluding their arguments this morning, and these, of course, are being led by Advocate Mhlongo. Thereafter, the defense will then be given an opportunity to respond to their state. It's not clear yet whether or not there is going to be a judgment in the matter, ruling by Judge Piet Koen, but that is unlikely. Of course, the proceedings today are going to be starting a little bit later than expected, and that is due to the fact that today the members of the judiciary here at the Pietermaritzburg High Court are going to be holding a memorial service for the late Judge Jerome Mnguni. Let me just to recap a bit on what happened yesterday and to get some legal perspective. It was a long day yesterday, starting, of course, with the arrival of the senior officials for the Department of Correctional Services, which was a surprise to many, and they had been subpoenaed by the state. For that, let me now bring in our legal expert, Mr. Mpumelelo Zigalala. Mr. Zigalala, good morning. I always appreciate your time. As I was just saying, surprise move yesterday when we saw Mr. Arthur Fraser and the two officials from Department of Correctional Services. Just to fast track, and I think they were here, of course, they were subpoenaed by the state, and we're going to, the intention was for them to bring evidence linked to former President Jacob Zuma's medical report. The interesting part is that a lot of people had anticipated that there was going to be a discussion. We saw the state was ready. They even had said that their medical team were on standby to bring testimony. But the judge saying that, pushing that matter aside and saying that it's going to be discussed at a later stage. Why do you think was it not pertinent that the issue around the former president, considering the fact that he in fact had said that he wanted to make oral representations in this hearing, but this time he was happy with the fact that the proceedings were going to continue without him?
It was quite a surprise, to say the least, because the anticipation was that because you are going to seek a postponement, because the former president is not here to be physically present, we are ready to oppose that particular postponement, and then we'll then expose through the medical records as to the inaccuracies of the medical records, or inversely to say that we have done our medical checks and he's indeed fit and proper to be able to come and stand in court. But the trigger to that is on the application that needed to be done by the defense. Without a particular application, we don't need to bring in the medical reports, you don't need to bring in the experts, you don't need to bring in Mr. Fraser and his particular reports, and because they said we are ready to proceed. Just remember, the Criminal Procedure Act does allow, in certain circumstances, when an application has been made and it is easy for you to say, this is where we are coming from with this application and there's no prejudice which is going to be suffered by the accused, to proceed without the accused being present. Especially in instances where the majority of the proceedings are going to be legal submissions in nature. There's no viva voce evidence that will be provided by any witnesses, and there are no instances in which you would need to go and get instructions as the proceedings are moving. So yesterday or even today, those are similar type of proceedings, which is why you are seeing the court proceeding without the former president being present.
I want to move in now about the timing of this application, and I raise this point because this is something that I understood. Obviously, my legal knowledge, where Advocate Mhlongo on the state mentioned the fact that this application by the defense should not have taken place now. Obviously, this recusal for the prosecutor, saying that it should have taken place either in the middle of the actual criminal trial or at the end. Your views on that? Was it the timing of this recusal application, seeing the fact that he has not really started to prosecute, and this I refer to Advocate Billy Downer?
I think he was basing his arguments on the leading case in this particular matter, which is the Parrot case, that has stated a number of times that The only time in which you make these type of allegations and they must be listened to by the court is during the trial, not at the start of the trial. Now, Section 106, for a narrow interpretation, or if you choose to take the narrow interpretation of it, it is purely administrative, where it says, do you have administratively the title to prosecute this particular matter? Have you been given the relevant authority by the minister or any other relevant body? Are you even a legal practitioner in order for you to allow to stand up in court and make submissions? If you tick all those boxes, then you suffice with Section 106. However, the argument by the respondents, or the applicants in this case, which is the former president, they are simply saying, you can't narrow the interpretation of this particular section to purely administrative instances. Let's expand it to conduct. We are going to prove to this court that the conduct in which Advocate Billy Downer has engaged in, it is so gross and so in contravention of the NPA Act and the Code of Conduct of the NPA, to such an extent that it warrants that we go beyond the actual confines of the narrow interpretation. I think that's what the court is going to have to deal with, and that's what the court is going to have to pronounce on. And if indeed they are successful, I must say that they are going to have crafted a new way of interpreting Section 106. If they don't, then the court would say, we're sticking to the conventional way in which we interpret this particular action. The only way in which you can continue with this type of argument, once the trial has started, lead evidence that will be able to show that your Section 35 rights have been infringed, and that may lead us to making sure that there's an acquittal order at the end.
The title, the prosecutor of no title, I think that's quite confusing, because to many of us, Advocate Billy Downer is an advocate, and so that's his title. But I know that legally it's not as simple as that. But just for our viewers who want to understand what the main argument of the defense was, when they say, when they speak about the prosecutor with no title, explain to us exactly what the point is.
Okay. Now let's separate between the two. There's a private prosecution, which is a totally different matter, in which where the NPA says, well, we do not have the appetite to prosecute this matter, you can go and get a private prosecutor employed privately to go in and step into our shoes and be able to prosecute. Now in this case, the title to prosecute simply means that the person who stands up there have been given the similar powers as that of the NPA. So they're acting within the course and scope of the act. They are temporarily employed within the NPA to do this part of prosecution. Another instance where this type of prosecution would arise is when, if you have a legal practitioner who is well vested in a certain type of law or in a certain subject of law, and there are sort of constraints within the NPA in terms of the employees that are there or prosecutors that are there, then you say to them, can you be able to prosecute this matter for me wearing the cloak of the NPA Act and the Code of Conduct? Prosecute it as if you are employed within the NPA. After that has been done, you need the permission of the minister and also the permission of the National Director of Public Prosecution. That is when you stand up in court, you will be able to say to the court, I've been given permission to prosecute on behalf of the NPA. Here are my titles to prosecute or certificates to prosecute, hence I'm eligible to be here. It does, when it comes to the conduct of the prosecutor and to how it handles themselves or herself during the proceedings, the leading case that we have now simply says, if you have an issue with that, bring it up within the trial stage so that you can be able to show those instances, and they may have a bearing on the right to a fair trial as protected by Section 35 of the Constitution.
Oh, that's the NPA coming out strongly yesterday, and even in the morning when we were speaking to the spokesperson of the NPA, Advocate Mhaga, was saying that it was in fact the Director of Public Prosecutions in KwaZulu-Natal that decided that Advocate Billy Downer was the one that was going to handle this case because of the wealth of knowledge that he has. He was a part of the Shabir Sheikh case, and so he has been working, and the experience that he has in this particular matter.
Definitely. You see, in that instance, then you say it covers me in the institutional knowledge of the matter. He's well placed to make sure that those arguments in which he is going to make have got a lot of background. He's researched the case law, he's researched the relevant legislation and common law, so he's the best person to prosecute in this instance. But it must come, if I must mention this, if you have an issue with the conduct and the way in which he has handled himself, then go and through the proper channels and complain. I had a bit of an issue with an instance where You only come at this late stage to complain. While these whole processes were taking place, there's nothing that you have done. So you haven't complained within the NPA, you haven't complained within the president, and you come at this late instant.
Right. Mr. Zigalala, I appreciate your time. Thank you so much for your legal expertise, and we know that you're going to be continuing to help us throughout the day as well. We're going to leave it there for now and take things back to you in studio.
All right, and a great analysis there by Mr. Zigalala. Thank you so much for joining us. We'll touch base with you a little later on. That was a reporter, Ayanda Mhlongo, speaking to us outside the Pietermaritzburg High Court in KwaZulu-Natal, wherein the recusal case of Advocate Billy Downer will be getting underway in the next, I believe in the next 45 minutes.